Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing K-1 fiancé visas and adjustment of status and possible new protocols associated with adjusting status, new protocols from a policy standpoint. So, first of all, for those who are unaware, those who enter the United States with a K-1 visa are only allowed to temporarily remain in the United States without taking further action. So, if they go ahead and marry their fiancé and file for adjustment of status, then they, presumably, if they're approved for adjustment of status, and that's the process whereby somebody goes from a K-1 visa over to an I-551 stamp or lawful permanent residence, sometimes referred to as a green card, that's how that person, they sort of make that transition from K-1 fiancé, get married, and then become a green card holder based upon their marriage. The adjustment of status process is the process for doing that. In a recent policy alert from U.S.CIS dated November 17, 2020, the following was noted under background. Well, first of all, purpose. Well, let's start at the beginning. Subject: the use of discretion for adjustment of status. Purpose: U.S. Citizenship and Immigration Services is updating existing policy guidance in the U.S.CIS policy manual regarding the discretionary factors to consider in adjudications of adjustment of status applications. Quoting further, for adjustment of status, the applicant has the burden of demonstrating eligibility, including that a favorable exercise of discretion is warranted. If the applicant otherwise establishes eligibility and U.S.CIS finds the positive discretionary factors in a particular case outweigh the negative, that's important, it's this balancing act, the officer should exercise favorable discretion and approve the adjustment application. Conversely, always a catch, quoting further, if the negative factors outweigh the positive factors, an exercise of discretion to deny is appropriate. U.S.CIS considers the totality of circumstances, which may include factors such as an applicant's conduct, character, family, or other lawful ties to the United States, immigration status and history, or any other humanitarian concerns to determine whether the applicant warrants a favorable exercise of discretion. I always get a little nervous anytime they create a balancing analysis. So, for example, we see this in the analysis of what's called Section 214B of the Immigration Nationality Act as it pertains to tourist visa applications. You have to show strong ties to your home country and weak ties to the United States. What I don't like in this new sort of guideline is the notion of the negative factors somehow outweighing the positive factors, especially in the context of something as elusive as conduct, character, family. Again, what that exactly means in practice remains to be seen, but it sounds rather ominous to me in the context of somebody looking to adjust their status, in that you're looking at very sort of amorphous concepts for making determinations about approving someone's application to adjust. So again, we'll make further videos on this channel as the situation progresses, but I think this is a major development, especially for those who are looking to adjust status from a K-1 visa in the United States.